Hey, actually, Chief, perfect timing because I was about to come on and ask people to share where you're from. So, Chief from Georgetown, Colorado, kicked it off, and he did something very important. He sent it to all attendees. Send your where you're from. Sonny, nobody saw that. Sonny, nobody saw that. Also, send your agency or what you do if you're not a cop to all attendees. Right? Look at the. There we go. Thanks, Sarge. Lexi, nobody saw that. Resend it out for me, please. Nobody saw that. Isabella, nobody saw it. Jacob, nobody saw it. Please resend it out to all attendees, please. What's up, Mark? Tiffany, nobody saw that. Please resend it out to all attendees if you don't mind. I want everybody to see it. You got to change your chat settings. By default, nobody sees it. By default, nobody sees it. What's up, Jody? Brian, nobody saw it. Tiffany, nobody saw it. There we go. Now we're cooking. Now we're cooking. Thanks, Isabella. Tiffany, nobody saw that. Tiffany, nobody saw that. And I'm assuming, Tiffany, are you Nevada? Nevada DPS? Richard, nobody saw that. My attorney friend from Alameda, nobody saw that. Resend it out to all. Guys, you got to change your chat settings. You got to select all attendees or nobody will see it. Please, Zoltan, Jacob, Medin, David, nobody saw it, my friends. Nobody can see it if you don't change your chat settings. So Tiffany, thanks. Are you from Nevada? Is that South DPS? That's Nevada DPS, right? Or that's Southern Academy? That's not Texas? I know it's not Texas. Good. All right, cool. Thanks, Jacob. I appreciate it. There we go. There we go. Everybody send it out to all attendees. Alyssa, nobody saw it, my friend. Nobody saw it. Please send out to all attendees. All attendees. All right. What's up, Jake? All right. So what's up, Jerry from Eureka? That's awesome. Okay, so check this out. Let's get started. Kurt, nobody saw it. Alejandro, nobody saw it. Please send it to all attendees. I'm begging you. I'm begging you. I want people to see where you guys are from. You have to manually change it. Zoom does not automatically send it to all attendees. Carlos, same thing. All right, guys, let's get started. All right. Hey, Kurt and so forth. Are you guys cadets from Nevada DPS, or are you guys instructors? Because you got a lot. There's a lot of DPS on here. Awesome. What's up, Tiffany? Awesome. Thank you. Okay, you guys know I'm a former. Do you guys know I'm former Nevada DPS? Is that how you guys know about me or no? Okay, cool. All right, guys, check this out. Let's start. We got a lot to talk about and not a lot of time to do it. Welcome to Search and Seizure Saturdays. Okay, so my name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue to Gold Law Enforcement Training. This is what I do for a living. I have the honor and the privilege to train police officers and prosecutors around the nation in search and seizure. I have experience as a full-time police officer. Like I have a lot of fellow former brothers and sisters that are from Nevada DPS on here, which is great, right? Johnny and Tiffany and Kurt, that's just great. So I mostly worked in Vegas, but I also worked in Elko, Nevada as well. So I have nothing but good things to say about DPS. So I'm glad you guys are there. I retired early and went to law school. I went to Gonzaga School of Law, and I live in Spokane, Washington. So I am coming to you from Spokane, Washington. I'm a little tired. And the reason why is I just flew back from New Jersey. I was there all week training about 90 police officers from around New Jersey and actually New York in search and seizure. So I woke up at 1:30 my time, right? Spokane time. So, but I'm happy to be here. I've been looking forward to this. So there's a little bit about me. If you want to know more, go to bluetogold.com. All right. So these 3 books, I just want to let you know that these 3 books I think are very helpful for your legal survival. That's what I'm here for. Okay. I'm trying to help your legal survival so that you win your court cases and you successfully defend yourself in court. All right. So that's what I'm here for. The search and seizure book, there's a California edition as well. There's a national edition, which applies, of course, to everybody, but there's also some specific states out there. And I see, a lot of California guys and so forth. All right. All right. So let's continue. So quick disclaimers before I get started. Number one, I'm going to, talk about the national standard, really the Fourth Amendment. I do not teach specific, divergences here for specific states. Now, if I know the rule and I see a Jersey cop here, or if I see, somebody else here that has a little more restrictions, I'll throw that in if you want me to, if I know it, right? But in Pennsylvania and so forth. What's up? That's awesome. That's up, Jeff. That's awesome, Jeff. What state are you in, by the way? What state are you in watching this from your MDT? I think it's great. Awesome. Ohio. By the way, I love teaching Ohio and I can't wait to get back there. Okay. So Francis, do me a favor, resend it out to all attendees. So if you, because I teach the national standard here, I'm just sharing with you that, it's not uncommon for states to have more restrictions, either A, under your constitution, right? Like the Pennsylvania state constitution, like my friend Jeff from PA. The PA constitution is a little bit more restrictive than other constitutions, but most of them are the same. But also, don't forget, state laws could also be more restrictive, right? And then, Doug, resend it out to all attendees. If you have any doubts about the legality of your actions, you got to either push up the chain and or ask your legal advisor, okay? I am not your legal advisor. I'm an attorney, but I'm not your attorney. I do represent police officers, but you got to be a client. So, for example, we have several DAs on this, on this webinar. Those are the type of people that you got to go to get legal advice. You can't get it from me, not through Zoom, not through this. And then finally, with that in mind, this is legal education, not legal advice. Okay. We have a new webpage up. Okay. We have a new webpage up that is designed to ask questions. Okay. So instead of just emailing us and not having any kind of framework, we have a new webpage. It's bluetogold.com/show, right? /show. This will help expedite getting your questions answered. So I answer questions in one of two formats. One is YouTube. I've had 42,000 new people have watched my YouTube videos this year, which is great. I mean, for a legal channel, not bad, right? I mean, I'm not competing with some of the other channels out there that are just getting millions of views. That's just not, they're not that popular, right? Maybe someday they will be. And then, so I got YouTube. So it's youtube.com/bluetogold. And then I do this show as much as I can, but I've been very busy lately. So my friend Jody, my friend Jody is an attorney with the federal government in LA. And it's been a while, right, my friend? It's been a while since we did a search and seizure Saturday. So, yep. So this class or this webinar comes with a certificate. It's a fill in the blank. In other words, if your state will give you credit for it, or if you are an attorney and you can use it for continuing education, go for it, right? Just do the certificate and you put I think it will be about an hour, no more than an hour and a half today. All right. Okay. So I got 4 questions I want to answer. And also don't forget that this webinar is also designed to answer your questions. So if you have a question for me, even if it's unrelated to what I'm talking about, ask it, put it in the chat. And for those who are new here, just so you know, I cannot see you and I cannot hear you. I cannot see you, I cannot hear you. You can only see and hear me. The only way we communicate is through the chat. So let's continue. So here's our first question. Actually, give me a second. I need my iPad, okay? Because some of these questions have long fact patterns, and actually no. Hold on. I can get it from my computer. Hold on. I have my dual screen here. I'll just pull it from here. All right. So here's the situation here. All right, so we have an officer who's asking about, can you basically pat down citizens who ride in your police vehicle? So the idea here is that, there's two types of people, I guess, that ride in police vehicles, right? Those who need a ride and those who do not want to be in your police vehicle, I guess, right? Those are, who are getting, it's non-consensual, and those who are consensual, right? You're giving a mother a ride home with her kids and so forth in a snowstorm, right? That's consensual. All right. All right, but but there is a safety always first. Andre, do me a favor, resend that to all attendees, right? But isn't there a little bit more to this question than that? So let me ask you, if you pull up and you say, hey, if I'm broken down on a city street, and I need a ride home, and you offer me a courtesy ride, can you automatically, without any other circumstances, can you pat me down? Yes or no? I think, okay, I'm gonna see. Andre, do me a favor, put that on. Okay, we got to clarify something. Okay. Yeah, I'm with Dimitri on this one. Let me share with you what okay, so first of all, let's clarify what's going on here. Okay. So this is an example. Okay. This is an example of how I use this book. Okay. So here's an example of how I use the book. So here is the Search and Survival Guide. This is what I teach. Okay. I'm not telling you what to do, but let me tell you what I teach. All right. So if a person is receiving a courtesy ride, right? Like Zachary just said, no consent, no ride. If a person is receiving a courtesy ride, they may be frisked for weapons if you have received consent to pat them down. It's going to be very hard to justify in court. I mean, it's not going to be impossible, but it's an uphill battle where you say, hey, Anthony, I see your car's broken down on a city street. I'm gonna give you an example of a freeway, but on a city street, I see your car's broken down. Do you want to ride? Right? I'll be nice to you. You want to ride? Yes, sure. Then boom, turn around. I'm patting you down. Whoa, whoa, whoa. What's going on here? I didn't ask for a massage. And the point here is, if it's consensual, then get my consent to give me that pat down. The courts are not going to like you spinning me around, right? Robert says, asking for consent to pat down is a huge mistake. Never ask for consent to pat down. Why limit yourself? Then the officer could end up with the plain field argument. Always ask for consent to search. That is actually true. That is a very good point, and I do teach that. Robert, are you an attorney? Because you're talking like an attorney, and I like, yeah, it's true. Robert is absolutely true. Where are you an attorney at? Are you in California? Ohio, nice. Okay. So Robert is correct. If you ask for a pat down, you're going to get a pat down, right? If you ask for a search, you're going to get a search. That's absolutely correct. Okay. And Paul also says, this is good stuff, man. I love this. Throw this in. Paul says also, always ask, even if you're legally allowed to, see what response you get. And also, if you're allowed to pat them down, I'm going to talk about compulsory pat downs for rides in a police vehicle. Even if your policy says it and you can compulsory do it, why not ask for that consent, right? Because there's two reasons why you want to ask for consent. Number one, it gives you another reason to do what you're doing, right, Paul? Paul, are you also, you're in Ohio too, right? So it gives you another reason. And and also, right? Oh, Iowa. Okay. The other reason is that it can actually expand the scope of search. See, a pat down is pretty limited. It's outside the clothing. You got the, just like Robert says, you have the plain feel argument that could always be challenged in court. Did you really have plain feel? So if you get consent, you have another reason. And if you ask for consent to search, you get to go right into their pockets. You don't have to start from the outside. You can actually do a search. All right. So rule number one, legal standard. Look what I have on the PowerPoint. So this is how the book is used. If it's a consensual transportation, seek consent. Now, a person being transported under a legal or policy obligation may be frisked for weapons if, you first ask for consent. I recommended. Do you have to? Probably not, but I want you to ask for consent. Now, if the consent is denied, a pat down for weapons will likely be considered reasonable if you are legally required to transport the person, or agency policy allows pat downs under the circumstances. So some policies will cover this. As far as NHP, I don't know what the latest policy is. I know you guys use Lexipol. I'm not sure what Lexipol talks about as far as this, but let me give you a case example, okay, from California. Here's what happened. Now, this is a California. Some people, I understand why, but some of my viewers, when I talk about California law, they start getting, they start saying, "Oh man, California is not. That's not going to be good law here." Well, I have good news for you. California is a Fourth Amendment state when it comes to search and seizure. The California is one of some of the best case law out there. But remember, it might be California, and it may be a nightmare statutorily and all the other regulations and all this other stuff going on in California. But when it comes to search and seizure, they're pretty on point. So just keep that in mind. All right, under the Fourth Amendment. CHP stopped out with a disabled vehicle on the interstate, and none of the occupants had a valid license. The vehicle was also unregistered. So no, unlicensed, unregistered. The officer decided to tow the vehicle and transport 3 occupants off the highway. Okay. The pat down was conducted and the officer got stuck with a needle. So that's our first problem, which sucks. I solved in the case and I just want to throw it in there. Always, please, please, please be careful and, try to get those gloves that are, that have some kind of barrier. But anyway, let's continue. And he found 25 grams of cocaine. So we know that in California, it's personal use, right? So my question for you is, here's the deal. The defendant, right? He says, I didn't give you my consent. I didn't give you my consent to pat me down. But the court did find that CHP had to take these guys off of the freeway. They could not walk off the freeway under these circumstances. Let me ask you, can the CHP officer pat them down without consent? Yes or no? Lawrence, change your chat settings to all attendees, right? The answer is yes. The answer is yes. The answer is yes. Here, the officer, here's what the court said, okay? Here, the officer had a duty to transport the defendant, the appellant. The officer correctly determined that he could not permit any of the 3 men to drive. One of them appeared physically unable to do so, and none of them were licensed. We conclude that exigency which existed and that the exigency which existed and the need for public safety supported the officers conducting a minimally intrusive pat-down search of this defendant's outer clothing. Okay. So, yeah. So, Sonny, we're good. Yeah. And we still have people. Now, the only thing, Paul, is here is a problem with California law. California law in this case, and it's, you guys are the statutory experts, but one of the issues in California law was that if you read the statute about disabled vehicles, they are allowed to go to the next exit to summon help. And the court did say that there is an argument in California that people can walk on the freeway if they break down. It would not be against the law for them to walk to the next exit. However, under these circumstances, they actually wanted to go to the other side of the freeway. They wanted to cross over, and the CHP officer was not going to allow that. That's a little different. So kind of weird, just so you know. You have to look at your laws. But generally speaking, I mean, we know that pedestrians, right? Pedestrians are usually not allowed to walk on controlled access freeways, but they're not pedestrians. They started off as motorists, and they turned into a pedestrian. So a little bit of a funky thing there, but you get the point. Yeah. So, but Robert, Robert, what we're looking here for, I agree. You cannot play, when it comes to convenience, when it comes to there's no specific issue, you got to be careful. So look, okay. Right. Exactly, Paul. So he transferred 3, yeah. Okay. So we're good here, right? We're good here. Okay. So the takeaway here is this. Here's the takeaway. If you are legally required, right? Let's say you're transporting a suspect back to the crime scene, and you're probably gonna need exigency for that, by the way. You're not supposed to be transporting suspects from the place of detention. That usually means an arrest. But if you have exigency and you got to move somebody, you're gonna pat them down. So, but if it's for consent, if you're just giving somebody a courtesy ride, seek their consent. If they say no, I would not force pat down them, and I would let them keep walking unless you have something else going on. Now, somebody asked about a question about DVs, right? Can you pat down the suspect and the victim? Well, when you arrive on scene, if there's been a violent domestic, and especially when you think that a weapon has been involved, you're probably, and you don't know who the primary aggressor is, it's probably a good idea to pat people down. Does that make sense? Right? I mean, if you have a weapon involved and you don't know who the primary aggressor is, we don't know who the victim is yet. Does that make sense? However, if you have established that the victim is a victim and they didn't have a weapon and so forth, I'm not seeing the reason to pat them down with the facts. I'm gonna need something more, because you need reasonable suspicion that they're a danger to you. And being a victim, of course, that doesn't work, right? Just being the victim of a domestic is not gonna be in their danger. Okay, so let me go with the next one. Okay, so you're welcome. All right, so are you guys good with that? My friend, my lawyer friend, we good with that too? Okay, so Jacob says, what about going into a house for a domestic? Here it is. First of all, I just want to let you know that there is no domestic violence exception to entering homes. It's not what it's called. It doesn't fall under that. Entering a home to investigate a domestic falls under the emergency aid doctrine. Okay? Emergency aid doctrine. So what we're looking for here is, usually, do you have a reason to believe that somebody in the home needs your assistance to protect them from violence? And with that, is that a level rising to some level of exigency? Usually not hard, okay? But that's how you get into homes under domestics. Does that make sense? So do you have a reason to believe, somewhat of a higher standard than somebody in the street, because you're going to a home? Do you have a reason to believe that somebody's in, imminent danger and needs protection? And, do you believe that that rises to the level of exigency? If the answer is yes, you get in there under the emergency aid doctrine. So there you go. Does that help? Okay, so here Isabella asks a question. Okay, this is good, by the way. I hope you guys are enjoying this. Isabella asks, if somebody has a CCW, okay, a concealed weapons permit, and is licensed to carry, legally, of course, right? They consent to a pat down, but they don't want the weapon removed during the interaction. Okay, here's the question. If they are being detained, if you have a legal right to detain them, the weapon is coming off of them. Okay, Isabella, the weapon is coming off of them. The right to carry a concealed weapon, right? And Andre, you're giving good feedback, but you're not putting, you have not changed your settings to all attendees. Okay, so, and no, there's a lot of pro-gun states out there, Nevada, a lot of Arizona, but here's the general rule. If they have a gun and they're being detained, the gun, it's up to you whether you remove the gun or not. All right, Isabella, does that answer? There you go. It's a bright line rule. The gun comes off if you want it to come off. All right? All right. If not what? They don't want to remove? And are they being detained? If they are being detained, it's not an option. It's not an option. If they are being detained and they have a weapon and you want the weapon to be secured, right? If you want that weapon to be secured, the weapon is going to be removed. They don't have a choice. It's not their choice. It's your choice. All right? It's your choice. It's not their choice. Well, if not detained, can remove it for safety? No, no, not necessarily. Not necessarily. That they have a Second Amendment right. You know, if you're just contacting somebody, let's say for example, okay, that's right, Paul. Right. If you're contacting somebody for a field interview, and you're just talking to them, and you're just, let's say they're a witness. Let's go with the witness. If they are just a witness and they are lawfully carrying that firearm, and you want to secure it, and they say no, I don't see how you're going to disarm them. They have not done anything wrong, and they're carrying legally. You're actually, in my opinion, you're violating their rights by disarming them against their will. Let me see what Jeff said. You can always ask. You can always ask. And if they say no, then you need to reassess what you're doing there. But look, the other thing, Isabella, I want to share is that, the other thing I want to share with you is that reasonable suspicion is a very low standard, right? Reasonable suspicion is a very low standard. So make sure the cops out there that are, contacting somebody that's not a witness, but a potential suspect, it's a very low standard. So there you go. Well, Paul says not a whole lot different from than stopping a car for speed. They tell you that they're armed and have a permit. No reason to take unless you have some other PC to believe some other criminal activity is going on. No. I mean, that's when I was a cop, I would not, Paul, I would not disarm people just as a matter of practice unless I believed that something else is going on. That's how I worked. However, when it comes to the law, people can be disarmed even if the gun, the problem is the gun is the danger, right? The gun is the danger. So if they're lawfully carried and if they're lawfully carrying and they are being detained, traffic stop, criminal, whatever it is, traffic stop, and the cop wants to recover or retrieve that weapon and secure it during the traffic stop, to me, it's a bright line rule. Okay, it's a bright line rule. It's up to the cop. I don't suggest you do that every single time because when you manipulate guns and you have more chances of an accidental discharge or negligent discharge. It's also, whatever. So that's my rule. That's what I teach. Okay. The manual says, and can you run the serial number on the traffic stop? You ready for this one? You ready for this one? You sitting down? Okay. The answer is most likely yes, especially if the serial number is in plain view. Okay, it's in a holster. You can pull the gun out, unload it. The serial number is underneath the frame or whatever. And running the serial number does not unmeasurably extend the stop. So, unreasonably extend the stop. So generally speaking, NCIC is very fast. And I have not seen a court case say that running the serial number in and of itself extends a traffic stop. Now, you also may have some other, of course, if the gun is not, if there's no permit or there's any other conduct going on that you believe the person is violating the law, then you can extend the traffic stop to run the serial number. But let's take me, okay? I'm going a little too fast, right? Let me go. Let's slow down. You make a traffic stop for speeding. You pull me over. Okay, you pull me over. And I'm always armed, right? That's just the way I roll. So you want to seize my gun during the traffic stop. And the answer, and I'm Anthony the lawyer, Anthony the ex-cop. Can you do it? 100%. Okay? So far, so good. Now, you take my gun and you want to run the serial number. Shouldn't be a problem. The serial number is going to be in plain view, usually, right? It's going to be in plain view. You can see the serial number. All right. And then running the gun through NCIC usually does not add a lot of time. So courts are not going to give you, in my opinion, going to give you a lot of heartache about it. But here's the problem. And I don't have a case on this, but I can see this being a valid argument. Okay. And my lawyer friends on here, you let me know if you disagree with this. But here's my problem. If the serial number is under a Hogue grip, it's under a light that you have to unscrew and so forth, and you cannot see the serial number in plain view, and you are manipulating my firearm, well, that is a search under the Fourth Amendment, right? And so that is the, so if the gun happens to come back stolen or something, the argument is that, okay, he was legally carrying it. You had no reason to believe the gun was stolen. It's for speeding. You are manipulating his gun to try to find the serial number. It's not in plain view. That is a search, and searches normally need probable cause. And that's the only thing I want to throw out there, is that I see that as an argument against if you have to manipulate the gun. So hopefully you have something else going on, and so forth. All right. Let's go here. Yeah. I mean, and that's their right. That's right, Andre. If the cop wants to pull that gun, you're good. You're welcome. Alejandro, you good? All right. Let's go to the next scenario. Okay. Next scenario. If you arrest a person outside their car for drugs, can you also warrantlessly search their car for drugs, right? Randy, clarify what you mean. Clarify what you mean. Give me a little more context about what the scenario is. So let me go through, as Randy, as you're explaining that, let me go through this scenario, okay? So if it's holstered and they hand you the holster with the gun in it, you can take the gun out, you can secure the gun. Is that what you're asking? That's not a search. I don't think that's a search, because you're allowed to pull the gun out to unload it. Does that make sense? So that wouldn't be a search in my book. Does that make sense? Yes. So if he hands you a holstered gun, you can take the gun out to unload it. And then now the serial number is likely going to be in plain view. Is that what you're asking? So let's see what Lexi said. Only what would be within the hand's reach. Can't go inside the trunk. Oh, you're asking about this. Lexi, what state are you in? Because that's actually going to be complicated. That's probably not going to be, we're going to talk about that. Idaho. Okay. I definitely have your answer in Idaho. What if the driver refuses what? To give you the gun? Go with your training. I can only tell you what I think the Constitution says. You got to go with your training, right? You got to go with what your agency wants you to do. So you got to talk to your boss on that one. But lawfully, I think you're good. All right, let's talk about it. Okay. So Sonny, you're welcome. Sonny, you're giving good information, but nobody saw those wise words of yours. Please change your settings to all attendees, my friend. Okay. Well, Randy, I would be careful about disarming. Was he on duty? Or, he was probably off duty. He was probably off duty, obviously. Right. That's going to be one of those. But in my book, look, in my book, the law is in the favor of the officer making the traffic stop. Okay. Let's talk about this. So there's two issues that this Idaho officer is talking about. Okay. One is searching a car incident to arrest. And the next one is searching a car with probable cause. Okay. All right. So first of all, if you arrest somebody from their vehicle, whether they're right next to it, they're recent occupants is a rule. It did work that time. No, it did not actually, Sonny. It did not. Nope. You got to put the drop-down menu and hit all attendees and all panelists. Thanks, buddy. All right. So here's the deal. Can you search a car? There it is, my friend. Can you search a car incident to arrest as a matter of routine? Right? As a matter of routine. If you arrested somebody from a vehicle and you detain, they're under arrest, they're outside, they're away from the car, And just as a matter of routine, can you go back into that car and search it as incident to arrest? As a matter of routine. Okay. The answer is 100% no. The answer is 100% no. And Scott is also talking about Arizona versus Gant. Well, let's not talk about inventory yet, Jerry. Not yet. Okay, let's just talk about, can you search the vehicle as incident to the arrest as a matter of routine? The answer is 100% no. Here's what, that's Arizona versus Gant. Okay. You don't necessarily need a warrant though either. Hold on. Let's do this one at a time. Okay. So here is when you can search a car incident to arrest. You ready for it? Here it is. Here's from Arizona versus Gant. The suspect is within the lunge area of the car. Okay. And he can gain access. Right? And he's not detained. So he's basically under arrest near the car. He's under arrest near the car and not restrained. That's the better way of looking at it. Under arrest near the car, unrestrained. When was the last time that you guys left an arrestee near the car while you're searching it as incident to arrest while this guy's hands are free? When was the last time you guys did that? I hope never, right? I hope never. It's just not going to happen, right? So you may search the lunge area of arrested but unrestrained, but it's not going to happen. If the guy looks like that, even though he's near the car, it ain't going to happen. It ain't going to happen. So that's the first thing. Okay. So you cannot do it as a matter of routine. However, if he is a recent occupant of the vehicle, follow what I'm saying here. Okay. If he's an occupant or recent occupant, and recent occupant means that you saw him come out of the car and you know he just drove that car, okay? And you arrest him for, let's say, drugs, and you have a reason to believe that there's more drugs in the car or more evidence, okay? So then you can search it. So listen to what I'm saying. Check this out. You ready? If he is an occupant or recent occupant and you arrest him and you have a reason to believe that more offense-related evidence is inside the car, you can search it for that evidence. That is also a holding from Arizona versus Gant. See, Gant stands for two doctrines. The first doctrine is they got rid of this whole routine searching cars as a matter of incident to arrest. That's done. Okay, that's done. Those days are over. But they did say that if you had a reason to believe offense-related evidence is inside the car, and he's a recent occupant and so forth, or current, wasn't immediate occupant, then you can search it for that evidence. That reason to believe is a lower standard than probable cause, but they have to be an occupant or a recent occupant of the vehicle. Okay? All right. So Iowa actually has a very, very, very tough tow policy, right? In Iowa, you have to give them an option to actually leave their car, have somebody pick it up. And actually, if they say, look, I do not want my car inventoried, probably shouldn't be inventoried, right, Paul? You just leave it there, and you basically, you document that they did not want an inventory and they're taking the risk. So that's the deal in Iowa right now. All right. So it is rough, but guess what, Kyle? I see right now you didn't send it to all attendees. But why do you think it's that way? Do you think the Supreme Court of Iowa just decided one day to just make it tougher, or do you think that cops were searching cars using an inventory policy rationale when they probably shouldn't have? Right? Exactly. All right. Ulysses, right? How about a quick search of the vehicle for weapons prior to releasing the vehicle to a licensed driver? No. No. You have to give me facts. You cannot do it as a matter of routine. You cannot get into people's cars when the car is going away and search it for weapons when you have no reason to believe, right? You have no reason to believe that that you're in danger. Now, somebody's asking for, you got to have a reason. You don't get any freebies under the Fourth Amendment. You don't get any freebies. Everything requires articulation to some degree. Somebody's asking for the slides. The good news is I don't give out slides, but I got good news for you. This video will be posted on YouTube by Monday. So you can have access to the video and rewatch it and show your friends and whatever. So searching people incident to arrest is done. Okay. I'm sorry. This is how tired I am, right? I'm not saying my words correctly. Searching a vehicle incident to arrest is done. You're going to have something else going on, which is either evidence-related searches or probable cause. All right. So now let's talk about probable cause. If you have probable cause that the vehicle contains contraband, fruits, or instrumentalities of a crime, you can search it if you have four things, there's four things that need to be articulated. Some people say probable cause plus mobile vehicle, that's all you need. Well, let's be more accurate. You can see it on the bottom here, the legal standard. It is probable cause plus lawful access. In other words, the vehicle cannot be in curtilage, backyard, carport, unless it was hot pursuit. Okay, so get that, but if the vehicle's just there and you have probable cause for the vehicle, and if it's on curtilage, you're done. You got to get consent or a warrant. The vehicle has to be readily mobile. Usually the courts are a little loose on this one. I don't have time to get into it, but the courts will give you a little bit of leeway on this one. Like broken down vehicles are still searchable under the Fourth Amendment. And finally, your search does not exceed the scope of the probable cause. You go where the probable cause takes you. So, for example, if you have probable cause that I put a backpack full of drugs in my trunk and you want to search that car, okay, so far so good. But then you don't go to the trunk first. You start searching my passenger compartment and you find other drugs and so forth. You have a problem on your hands, right? You have a problem. That's right. Get the trunk, go to the trunk. That's where the probable cause took you. Search the backpack. And if you have a reason, if you have probable cause that there's more evidence in the passenger compartment, then go for it under the motor vehicle exception, right? But if you don't, then you're done. Imagine that I'm going in an Uber, right? And my backpack has drugs in it. I put the backpack in the Uber and we start driving. You pull the Uber over. You're not going to get that Uber, right? You're not going to get the whole car. I mean, and you better, you might get my little passenger compartment area, but if you start tossing that whole Uber with just as a matter of routine, you have a problem on your hands. So you get the trunk, you get me, you get the backpack, you get me, you maybe get my space, maybe I put something under the front seat, you get my point, okay? And if I'm not wearing my mask, then you have a COVID felony. So to answer the Idaho officer, right? So if you arrest somebody for drugs near their vehicle, can you search the car? No, not as a search incident to arrest, because the guy's going to be in handcuffs and he's going to be away from the car. Can you search it? Do you need a warrant? Well, if you're telling me, because that's what he's saying in the fact that I'm looking at it, he says, well, I need a warrant. Well, if you think you can get a warrant, well, you're also telling me you think you have probable cause. Does that make sense? If you think you can go get a warrant, then you have probable cause. If you have probable cause, you have the motor vehicle exception. you'll find in here that the vehicle does not need to be occupied or recently occupied under the motor vehicle exception. It's searchable simply and directly. Okay. U.S. versus Ross is your main case there. You search the car in the same manner as if you had a warrant. Now, if you want to avoid this complication and you want to give your DA a little break, right? Go get your warrant. If you want to have an easier data, and have no suppression hearing or have an easy suppression hearing or an easier, go get a warrant. If you want to, take your chances and go, and have more, just have a little more challenging case, then search without a warrant under the motor vehicle exception. Now, again, that is under the motor vehicle exception. So most states like Idaho complies with the federal standard. So there are the 4 requirements, okay? Probable cause, not within curtilage, apparently mobile, don't exceed the scope. So what about other occupants in the vehicle if you have PC to search the rest of the car? Okay, so I think I'm actually going to talk about this next week on Wednesday. Hold on, because that's a big question that has a lot of answers. Hold on. Let me. I think I have a webinar on that. Let me see what's coming up, because it's called Searching Cars and Occupants. Hold on. Because I'm going to try to push you to that, because it's a long answer, but I'll give you a quick answer, but I'm not going to go in depth on it because, okay, look, Wednesday, guys, join me Wednesday, okay, on Zoom. Join me Wednesday. Let me see what time it is. I think it's 6 o'clock Pacific, and I got to verify. 6 o'clock Pacific. Oh, 1600 Pacific. Thank you. Thank you. All right. So, Weston, to give you a quick, thank you, Jody, a quick answer, okay? Here it is. You cannot search occupants, okay? You cannot search occupants as a matter of routine, even if you have probable cause for the vehicle, okay? That's not the way it works. In order to search occupants, the driver is usually pretty easy, okay? The driver is pretty easy. But in order to search an occupant based off of the PC of the vehicle, you need what's called a nexus, okay? You need a nexus. You need to tell the court, why do you believe that this occupant is associated and has something to do with the probable cause? That's kind of what we're looking for, okay? If you don't have that, if you have nothing, if you go to court and you say Your Honor, I searched the car because I had probable cause for, I searched the occupants because I had probable cause for the car. You are going to lose, okay? You are going to lose. That will not work. That has been the rule of law since 1947 in a case called U.S. versus D. Rye. I think that's what it's called. Okay, let's continue. All right, let's continue. So yeah, Wednesday at 1600 Pacific. Okay, the ultimate question when it comes to these car searches, okay? The ultimate question when it comes to warrantless searches of a car is, if you were to seek a search warrant, what would you articulate to a judge? What would you tell that judge? Why would you want to search the car because you arrested this dude outside next to it? Why? If I'm your judge, what are you going to tell me? If you got nothing to tell me, and you're like, Anthony, I'm doing it as a matter of routine, or, well, he owns the car, that ain't going to work. You need probable cause, all right? Or a reason to believe if he's a recent occupant. Right, no fishing, right? Here's a question from Kansas. All right, this one is a little bit long fact pattern. So let me see where this one is at. All right. Hold on, I'm sorry. That's not it. Hold on. Here it is. Okay, you ready? Let me just kind of read what's going on here, okay? So I'm going to disagree, Lawrence. Check this out. Let's read the fact pattern first. Okay. An officer was trying to make a traffic stop. He made contact with the driver and the only occupant of the vehicle, and he smelled the odor of fresh marijuana emanating from the vehicle. This is Kansas. It's still illegal, at least when he told me when he gave me the question. Okay, so the driver then fled. He fled to his house. He ran into his house. They pursued him under hot pursuit. They went into the home. He barricades himself into a closet. They make a forced entry into the closet, and they get him in custody. Okay? Francis, it's his house. Change your settings to all attendees. It's his house. So what they want to do is, after they got him in custody, okay? They got him in custody. What they want to do is they want to go through the house everywhere that he has been, right? Where they think he went. And they want to look to see if he dropped anything and so forth. All right? Can the cops look in the exact same place where he fled, those rooms where he fled into, in the hallway and so forth, to see if he dropped anything? Yes or no? Okay. Thank you, Jacob, for at least saying, okay. The answer is no. No, 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 no. And actually, let me tell you why this is, right? Well, hold on. I'm going to talk about protective sweeps. But if you go to court, okay, if you go to court and you say, you got this guy in custody. Jody, your settings didn't go to all attendees, and you know better, my friend. This is like your 40th webinar. So I want my BFF on here to share her comments. So if you go to court, okay, and you tell the court, let's say he went into the bedroom, and then he went into, and then he went to another bedroom, and you found him in that other bedroom, and you go into the first bedroom that you believed he went into, right? And you find some drugs, weapon under the mattress or between the mattress, okay? Because he could have ditched it there. And you go to court, and the court asks you, officer, why did you search between that mattress in that other room? And you say, because he went in there and he could have ditched evidence. I promise you, you're going to lose that evidence, okay? You're going to lose that evidence. There's no way you can do that. You can never, ever, ever search people's homes outside their lunge distance for evidence. You can't do it. You need crew. Crew, for my new folks here, is consent, a recognized exception, right? Like exigency, right? Exigency, usually for homes. Homes are the vast majority of searches. Warrantless searches involving homes require exigency, or a warrant. Now, in this case, they had the girlfriend there, and the girlfriend is telling them, hey, you cannot search my house, or our house. You need a warrant for that. Now they're really, even more so cooked, right? Okay. So let's go through it. So let's talk about protective sweeps, okay? Let's talk about protective sweeps. And I think, yeah, Jacob, we're on the same page, okay? So protective sweeps, there's 3 sweeps that you can do to a home, okay, in hot pursuit. If you're in the home lawfully, and you arrest somebody, there's 3 sweeps that you can do. I call them zones, zone 1, 2, and 3. Let's go through it. So Sonny says, just confirming, this case is hot pursuit of a suspect for a misdemeanor. Sims versus Stanton says no, since hot pursuit was not a felony. Better get a warrant. Actually, Stanton versus Sims, I believe it's Stanton, doesn't mean anything. You'll still find it. I may be wrong. Jody, confirm that for me. But that's not what Stanton says. Stanton actually doesn't take a position on it. Stanton is a case from California where cops are chasing a guy for basic obstruction, PC 148. And they basically go into the guy's curtilage, and somebody gets hurt and so forth. The U.S. Supreme Court did not take a position on a case. They said that the cop was deserved qualified immunity. Basically, the law was not clearly established. Unfortunately, the court did not really establish the law. They just said, look, Stanton is, we're not going to decide here, but it was not clearly established either way, so there's no liability. So that's not, right? That's not what Stanton stands for. The vast majority of case law actually allows cops to chase people into their homes for an arrestable offense. The fact that it's a misdemeanor, because I'm not saying it's not important. It's very, very important. And you got to be, you got to be very careful in this. But the problem is if you're outside on the street and this guy runs into his house and you can't go get him, well, everybody's going to have an incentive to go run into their house and say, not it. So we don't chase people for reasonable suspicion. We chase people for an arrestable offense. If you detain somebody outside their house for reasonable suspicion and they take off on you and try to get into their door and you chase them and you detain them, you have most often an arrestable offense. That is obstruction, and so forth. So that's the problem. So there is no Supreme Court case out there that says that you need a felony before you can go chase somebody in their house. So you need an arrestable offense. And so that's where it's at. All right. So, all right. DUI would be a good example. People run into their house all the time, being chased by DUI, and cops will go in there into their garage or whatever and get them in custody. That's hot pursuit. So, and that's a misdemeanor usually. All right. So let's talk about it. Sonny, if you don't agree, I'm totally cool with it, right? But I can also send you that case and highlight what I'm talking about. Okay, so here are the three zones, right? Immediate control, right? So if you are in the house and you get this guy in the closet, you can certainly look for areas that are small enough to carry, to possess, to conceal a weapon, evidence of the crime. That wouldn't really be anything here, I don't think. Maybe the weed, maybe he took the weed with him, I guess, right? Or means of escape. So these are small areas that are in his immediate control. This case is Chimmel, okay, a 1960s case, but old school case, but this is Chimmel. So you can search the immediate area under his control, all right? You get that as a matter of law. You do not have to justify anything besides a lawful arrest in the home, okay? Okay, now Weston actually asked $1 million question. So here's what I teach. The law is not very clear on this issue, okay? The law is not very clear on this issue, but I'm gonna tell you what I teach. This immediate control search or immediate areas, you can call it lunge area, you can call, but it's a small area. It is done, in my opinion, when the guy is in handcuffs, checked for tightness and double locked, and he's being cooperative. You hear me? Handcuffs, check for tightness and double locked, and he's being cooperative. If he's all three of those, it's done, in my opinion, because it's not very sincere to keep searching stuff when the guy has no access to anything. You're controlling him. If you move him to a couch, can you sweep the couch? Of course you can, right? So Weston, does that answer your question? This search does not go on forever, and do not move this guy around just so you can search small areas, okay? All right. Next, adjacent areas. If you arrest the guy in his bedroom and there's a walk-in closet and a bathroom attached to that room, you are allowed to look in those areas. This is also Chimmel. You're allowed to look in those areas for people in people-sized places. I repeat, you're allowed to look in those adjacent areas for people in people-sized places, but do not look in the medicine cabinet. Do not look in drawers. You can't do that. I had a cop in California that looked in a blue tote, right? Like a blue, big tote. And he moved the lid off and he found a gun. And the court threw it out. The cop testified that the reason he looked in there was because little people could be inside the tote. And that is certainly possible, but that is not going to work unless you have some reason to believe that little people are that living at that house or something and pose a danger to you. It's just, I like to say, just because it's possible doesn't mean it is probable. You need some probability, whether it's reasonable suspicion, a moderate chance, a fair probability at probable cause. You get my point. Anything is possible, but is it probable? And that's right. I figured you'll like that, right, Logan? And then finally, we have we have throughout the home. This exception is based off of a case called Maryland versus Bowie. Maryland versus Bowie. You can look, it's not automatic, okay? You can look in other rooms that are not just adjacent, but let's say upstairs, downstairs, back bedroom, and so forth. You can look for other people if you have a reason to believe somebody is in the home that could pose a danger to you. You do not get the entire house as a matter of routine. You just don't. Maryland versus Bowie does not allow that. They have a privacy expectation in the rest of their house. So this is not a high standard. I can tell you by reading case law, the courts aren't looking for much here, but you got to give them something. It's a gang house. You're arresting the guy for a felony and there was another accomplice involved. That person is still outstanding. Yeah, you're probably going to be able to sweep the house for the accomplice. You hear whispers in the back bedroom as nobody's coming out. There's a bunch of cars in the front driveway, but only one dude is in the house. Where are the other people that own the cars? Why aren't they showing themselves and being more transparent? You see my point? So the first two you get on the house, the last one you get with articulation. So therefore, do you see anything in here? Do you see anything in here that says that you can look throughout the home for evidence, right? Under protective sweeps. Do you see anything like that? Right? The only one that gives you a right to search for evidence is only under his immediate control. Everything, if you're going to go out and branch out and go to other zones, right, inside the adjacent areas and throughout the home, you only can look for one thing and one thing only. And what is it? Right? One thing and one thing only. Black and white law. People. In people-sized places. Now, we have the other issue, okay? So we do a lawful, search and we go from there. Now, I'm going to show you a video, but I do have to, this video will be posted on YouTube on Monday, as I told you, but I'm not going to post, I'm going to cut this video out because YouTube will give me a copyright strike anytime I use anybody else's stuff, even though I believe it's fair use. So I'm taking this out. So my folks that are watching this on YouTube, I'm sorry, blame YouTube. All right. All right, so again, for my YouTube people, we're back. We showed the video. They had to get cut off. And so it basically shows some cops going into a house, chasing a guy, but they re-enter the house. And that's how I'm talking about that. And Robert, is it your position? Is it your position that nothing needs to be articulated? For adjacent areas? Yeah, okay. I think Robert, are we on the same page or no? Okay. So, all right. So what legal issues? Let's talk about it. So first of all, look, lawful hot pursuit, of course, right? I mean, they also got it's Texas. That's a good point, right? They also got a warrant too. So that's a no-brainer. But I want to ask you, what if they believed that he went down the hall, right? And then let's say you chase him into the house and he goes down the hall and then, I see. Correct, Robert. Yes. Just have I think the language I use is just a reason to believe you're in danger not for the adjacent areas. Those are automatic, but for the rest of the house. Just something to give the court, right, Robert? Just something to give the court. Very, very low standard. I say reason to believe. See if you agree with that. That's what I teach. Okay. So if he went down the hall and came back, right? And now he says, okay, I'm under arrest. See, if you go down that hall, right? If you go down that hall, right? And you are looking there and you find a gun and so forth in plain view, and you go to court, okay? Let's say, again, it's down the hall. He came to you. He's under arrest, okay? And you go to court and you say, and the court asks you, why did you go down to the end of the house? And you say, because I was searching for stuff that he may have discarded. You got a problem on your hands. There is no exception to look for evidence in that dude's house, okay? You're going to need a warrant for that or consent. But if you have a reason to believe that somebody could be down there that could be a danger to you, and then you go down there to sweep it for people in people-sized places, and you find the gun, you are good. All right? Does that make sense? And Robert and I are on the same page. You do not need any PC or RS, nothing for immediate area and adjacent areas, but you do need something for the rest of the house. That's buoy. All right. Right, Robert? Okay. So what about the reentry? What about the reentry? Are we good with the reentry? Oh, okay. That didn't, that was it Franciscus? That did not go to everybody. Resend that question out to all people. Okay. So here's the rule. Okay. Here's the rule. Generally speaking, when you leave the house, okay, when you leave the house, you lose the house. Okay. That's it. Start with that framework and we go from there. If you leave the house and you re-enter, you're going to have a lawful reason to enter, right? Especially when you're not going to freeze it for a crime as a crime scene. I mean, can you re-enter to seal up the door, to get the animals in control? So, you know, if you're going to arrest them and you want to get animal control, can you re-enter to put out the candle? Yes. But if you want to go re-enter to grab evidence that he may have discarded, you're going to have, and you left the house, you got to have what's called necessary and continuous. That's the doctrine. That's kind of, you have to have a reason to leave the house, and I think you have that here. And the re-entry has to be like immediate, right? You know, as soon as possible. Do not take breaks to go talk to your detectives and then bring them with you, and that will probably make it stale. Now, if you care about your evidence and you could have gotten it under plain view, and you had to leave, and time starts, you know, things start getting stale out there, you should go get a warrant. Now, let me ask you a question. If they were in that house, right, and they went up to the attic and they found 20 kilos of cocaine in plain view, is that evidence coming in? And the answer is no. He didn't go up there. Even if you thought there was evidence up there, you cannot search for evidence. You can only grab and go. Robert says, in the El Paso case, the house looked dilapidated, but if the officers believe it was just committed a burglary by fleeing and running into a random house, that's another reason too, by the way. That's not just hot pursuit, but you also might have exigency for emergency care, you know, emergency caretaking and so forth. All right. The emergency aid doctrine. Yeah. So, yeah, we're on the same page, Robert. I agree. So actually, there's a twofer. You know, there's a twofer there. If you thought the guy just entered some random house, you get in there also under emergency aid doctrine, not just hot pursuit. The takeaway here is that you can never search for evidence in areas that are beyond the immediate control of the arrestee. You can only search for people in people-sized places. I hope that helps, right? And let me just talk to you about plain view before we go. Okay, plain view before we go. And if you have, I might have one more question I can probably answer quickly. Okay, you guys enjoying this? Hopefully you're getting something out of it. I'm not wasting anybody's time. Okay, so I'll try to get that last question in too. All right. So plain view. Remember, plain view is nothing more than right to be, right to see. Right? Thanks, Robert. And I appreciate, I love having fellow attorneys on here too, because I love the, you know, just giving the extra viewpoints too. So plain view is right to be, right to see, hear, smell. The only one that gets touchy under plain view is when you touch things, you manipulate things, right? Now, if you have lawful access, in other words, if you don't have to make another constitutional entry, you get to grab and go. You're welcome, buddy. You get to grab and go. Let me give you an example of plain view, but no lawful access. You're walking by an apartment. You look in the window. You're on the sidewalk, and you see a kilo of cocaine on the kitchen table. That's plain view. Can you grab it? No. I didn't give you enough facts, right? You can't grab it. You're going to have to seal the place and go get a warrant. But as you're looking in there, you see the occupant of the apartment come out from the bathroom. He sees you looking at the kilo of coke on the kitchen table. He grabs it and runs to the bathroom. Can you now enter and seize the evidence under plain view? Still, the answer is no. But you can seize it under imminent destruction of evidence. Remember, plain view seizure requires that you have to have the lawful access to begin with. Plain view is one thing, seizing is another. If you're now, so that's going to be imminent destruction of evidence. Change the facts. If you're in a house, right? If you're in a house conducting an investigation for domestic violence, right? You're welcome. And you're in the house and you look over and you see a kilo of coke on the kitchen table while you're talking to the husband and your partner's talking to the wife and so forth. You then seize it. Is that seized under plain view seizure? Yes, because you're lawfully present. It's immediately apparent as contraband. You don't have to make any other entry or constitutional entry and so forth to grab the cocaine. That's plain view seizure, right? Right on. That's great. I'm glad I'm helping my new brothers and sisters that are going to take over this job, right? And I just want to say I'm sorry that you guys are becoming cops and you didn't pass the firefighter exam. I do apologize, but we do need the people. So thank you. And that was a joke. So relax, right? That's the right. I'm sorry you did not pass the firefighter exam. Hey, you know there's only two professions that make money in bed, and one of them's a firefighter. Did you guys know that? All right. So let's wrap up here. All right. So plain view, including plain view, is right to B, right to C. All right. So you are always allowed to grab and go with plain view. If you are lawfully present, right? If you are lawfully present, you can grab and go, but you need a search warrant or consent to search or process a scene. Right on, Kimberly. Okay, our last question for the day. Question from California. If a child witnessed a crime, can the uninvolved parent prevent the child from talking to police? What's your answer? All right. So let's walk through it. Okay, let's walk through it. So first of all, let's get Miranda out of the way. Okay, let's get Miranda out of the way. I'm going to give you my answer. But I want to walk through it step by step. First of all, I want to make sure that officers are not thinking that we have a Miranda problem here and so forth. If the mother said, "Hey, I'm invoking my son's Miranda rights," well, there is no Miranda requirement because he's not in custody. That's right? He's not in custody. So Miranda requires as they say, the 3 C's, right? The 3 C's: cops, custody, plus questioning. I know that questioning is not a C, but it sounds like a C, so that's how we remember it. You need the 3 C's: cops, custody, and questioning. Since he's not in custody, and also the questioning is not there either, we're not asking him questions that are likely to elicit an incriminating response. So we don't have custody or question. So let's get that out of the way. All right. Now, the child witness would not have a Fifth Amendment right to remain silent. So whether he says it or the mother. So let's get that out of the way. However, a material witness may be detained and identified, but if they remain uncooperative, they must be released at some point. Otherwise, it may turn into an unlawful arrest. So here's the problem. First of all, I want to make sure that we're talking about a material witness. Do not detain witnesses that are just, a little extra padding for your report and so forth. We don't ever want to detain anybody unless we have, lawful authority. And there is limited case law on this, but, the courts will give you, in my opinion, a little bit of leeway to detain people on scene that are vital for your case. I'm thinking of like the drive-by shooting and a witness says, "I saw it, but I want to cooperate." Let's identify them, try to convince them to cooperate. But at the end of the day, if they do not want to cooperate, they got to get going, right? So let me share with you a case out of the Ninth Circuit involving detaining witnesses, and it became unlawful, right? So this is the alleyway in question. Here's what happened. A group of 6 teenagers, high school students, okay? 6 teenagers are in this alleyway right here, and it's before school, and they're like, I think they're like in a semicircle or something, and one of them is waving around an airsoft gun that looks real, obviously, waving around a gun, airsoft gun, and singing music. And LAPD is called. They show up. They end up shooting the kid. My discussion is not about the shooting. It's about what they did with the friends. LAPD detained the 5 friends for 5 hours. Here's a picture from the case. Okay, 5 friends, 5 hours. Houston, do we have a problem? Right? And the answer is yes, because at some point, LAPD knows that the 5 friends committed no crime. They are a witness to a crime. I mean, maybe brandishing and so forth, but we have no evidence that they committed a crime. Hanging out with somebody with an airsoft gun is not a crime in LA, right? It might be a crime for the kid, but not for these guys. So they sued, and the Ninth Circuit gave them money, right? So no qualified immunity, and the suit can move forward against the officers. So there's there's that. Okay, so here's my feedback. I actually do not believe that the parent could prohibit the child from providing a statement. I do not. Okay, I don't see legally what the legal right is to prevent a person, child or an adult, somebody from giving evidence to the police. Okay, I don't see it. However, you're not going to be able to solve that problem in the street, right? You're not going to be able to solve that problem in the street. You're going to need somebody like Robert to come along and subpoena them, right, Robert? You got the subpoena power, Jody, and so forth. Cops don't have that power. So that's the only thing I can think that we can do here. So if it was me, I would identify the kid, just try to get his information, get the parents' information. I would leave. I would call my DA, and I would go from there, right? Otherwise, if you detain the kid and the parents, you're going to have a bad day in court, right? You're not going to be able to do that. All right, you already answered this. This is the end of the webinar. We're a little bit under an hour and a half. So I love the questions. Keep them coming. Right? Here's what I ask, right? Right? I only have subpoena envy, right? So look. So here's what I ask. If you like what I'm doing and you want me to keep doing, look, I'm taking time away from my beautiful family. I've been gone for 7 days. I got off the plane at noon. I came here home, and the first thing I did was get the studio ready for this thing. So I put a lot of work into this, and I just ask you, help me spread the word. Consider taking our training. If you do that, you have paid me back. And also, I would love for you guys, if you want to send me a patch or something, right? An agency patch would be great. Let me show my friend Jody. Hold on. So Jody, our friend Brad, sent me, right? We got Ellis, right? Look at Jody, right? So this stuff means a lot to me. I like the patches. I'm trying to make a wall. So if you see Brad, I was hoping Brad would be here to thank him, but I just got it today. So. Well, Jennifer, I teach at North or Metro. I actually have a class. I have a class at Metro. I was already at Metro in September. I was in Metro in September, and I'll be back. I don't know. It's on the calendar. I can check for you though. So, no, I don't. I do not have Clark County Police. So here's my address. Nice. I need Phoenix. So here, you guys are the best. So I really appreciate this. Here, let me give you the address. It's on the website, but I'll give it to you real quick. That'd be awesome. In fact, I got another one from Wyoming Highway Patrol that just came in too. So I need Phoenix. I don't have a lot of them, to be honest. I've never really been very aggressive about it, but now that, you know, I have this opportunity, I like to get these patches. All right. So this is really cool. Look, boom. Thanks, Shane. I appreciate it, brother. Colorado. I don't think I have any from Colorado. So I don't have a lot. All right, guys. So there's our training too. There's the, oh, dude, challenge coins. I don't want to be greedy, but I collect challenge coins too. Challenge coins would be here. Thank you. That's all I have in the office with all the employees. That's great. And in the employees, I put up all the challenge coins and the patches. I'm putting up the patches. So just to build that law enforcement pride. That's where this is going, on the wall at the office, so that the employees have the law enforcement pride. Yeah. Yeah. You can send it to that. Yeah, Jennifer, to that address. That's great, Nicholas. I appreciate it, man. Thanks, Zach. Awesome. Love it, man. Love it, love it, love it. Thanks, Andre. I appreciate it, man. Thank you. Guys, thank you so much. Hopefully I'm going to go spend some time with my lovely wife and see if she's still here or if she left me for a firefighter, and take these other classes. I have a passion for training. I'm online all this week. I'm doing advanced search and seizure, traffic stops, bulletproof report writing, right? I'm doing de-escalation. I'm doing duty to intervene, all that's good stuff, man. So guys, thank you. God bless all of you. I appreciate it, Jennifer. And go to bluetogold.com to see our calendar. So live, in person, on demand, all that kind of stuff. Thanks, Jody. Also, I improved that class too. You might be happy. I added some new stuff to that class too, to my report writing class. You're welcome, Francis. You're welcome, buddy. I will, Jennifer, right? Definitely. All right, guys. Bye, my friend Jody. So far, LA is still a go. All right. There's no doubt about it. Jennifer, there's no doubt about it, my friend. There's no doubt about it. All right. Awesome. So Wednesday, I'll see you guys Wednesday, 1600 Pacific. Yeah. So Jody, hopefully I'll see you in February. Thank you, guys. Peace out. Thank you for the patches and the coins too. That really means a lot to me. It means a lot to my staff. They love that stuff. So we're going to build up the law enforcement pride at the office. Thanks, guys. I'll see you Wednesday.